And the issue that we're looking at today is about how the courts have been impacted by COVID. In England and Wales, there's been a number of studies to try and identify at the outset what the potential issues are. And that includes the report on the impact of COVID on family courts by the Nuffield Foundation's Family Justice Observatory at the request of the President of the Family Division in England and Wales. There's also been a rapid review by the Civil Justice Council, which was conducted by Dr. Natalie Byram from the Legal Education Foundation. In addition to that, there have been and are currently ongoing inquiries by the UK Parliament's Justice Committee and by the House of Lords Constitutional Committee. Unfortunately, we have nothing comparable in Northern Ireland, and that is a bit of a gap. And today's webinar is a chance to start an important and urgent conversation to try and understand what we need to think about in our approach to recovery and what the strategic priorities might be from different perspectives. Obviously, it's only an hour. We won't be able to take an exhaustive look at the issues, but we hope that this will be the thing that will spark further discussions and actions on the issues that come up. So we're going to hear from 5 speakers today, each of them speaking from very different perspectives on the impact of COVID on the civil and family courts in Northern Ireland. And thank you so much to our speakers for giving up their time and their expertise to be part of this conversation. So let me introduce the speakers and then we will open the floor to them. So first we will have Peter Looney from the Chief Executive of the Northern Ireland Courts and Tribunals Service, who will have operational responsibility for much of what we're looking at today. Then we'll hear from Mr. Justice Michael Linden QC, who is a High Court judge and so will be able to give us a perspective from the bench. He's also the chair of the Shadow Civil Justice Council. We'll move then to Jerry McKerney, who's a personal litigant, and we'll hear about how the pandemic has impacted on family proceedings that he's involved with. Then we'll speak to Suzanne Rice, who's the Senior Vice President of the Law Society, and then we'll hear from Sarah Ramsey QC, who is the outgoing chair of the Bar Council for Northern Ireland. So we're going to kick off with Peter. So at some point, Peter, you'll be unmuted, and then we'll let you go.
Okay, thanks, Grania, and thanks for inviting me to come along to speak at the webinar. As Grania mentioned, I'm the chief operating officer now, and I'm responsible for the administration of courts and tribunals in Northern Ireland. And I'm going to do my best not to cut across what Mr. Justice Michael Linden is going to talk about. He's come along to talk about the COVID impact and recovery from a judicial perspective and what they've been doing. But you'll appreciate that there is a significant amount of overlap. We work hand in hand with the judiciary. Our statutory role is to support them and to support the administration of justice. In the 5 minutes that I have, I want to look at how we responded to the initial impact of COVID and the lockdown, and explain the work that's ongoing and work that's in the planning to try and increase the capacity of courts and tribunals in Northern Ireland. Being good civil servants, we had business continuity plans for a wide range of scenarios. We even had one for pandemic, flu pandemic. What we didn't have was a business continuity plan for a message coming from central government, which was stay home, stay safe. Our flu pandemic continuity plan was based on losing 30% of staff, so we were in a completely uncharted territory, and it has been a challenge in learning how to respond to it, and I think I need to be very upfront about that. Throughout this period, we have had staff in court offices trying to support what was classified as urgent or essential business. So we always have had a presence in court. To allow us to comply with the government message of allowing staff to stay home, we consolidated at a very early stage from all our court venues down into 4 operational hubs. That was at Laganside in Belfast, Derry, Dungannon, and then the 4th one was Craigavon, which subsequently became Lisburn. The Royal Courts of Justice also remained as an operational building, but those 4 hubs were the ones that were doing all the business on a day-to-day basis for a long period of time. There was a focus on making sure that urgent business that absolutely couldn't not be done was processed, and it was for the most part there was a focus on criminal. So it was custody cases, it was cases where there were issues around liberty, but it was also urgent orders in relation to civil and family business. So protection orders, non-molestation orders, orders in relation to the care side of family proceedings. So all those things were still going on throughout the pandemic. There was a process was introduced to try and allow cases to be managed in a different way. So a lot of the legal representatives were asked to fill in templates, giving an update on the status of their case, so that the judges could then decide in an informed way, well, what needed to be brought to court and what could be dealt with in a different way. So I'm not going to say more about that because I imagine Mr. Justice McAlinden will touch upon that. But during this initial period, my staff were working on a number of different work streams because we knew that we needed to ramp up our capacity to deal with more business. First thing we needed to do was create more capacity for staff to work remotely so that they could more effectively support court business from home. And there was a lot of building of laptops and sending those out to get more staff working effectively. And we did see very quickly, we saw the number of staff who weren't usefully engaged dropping down to more acceptable levels. At the same time, we also saw more staff coming in to court offices because, like it or not, we have a very paper-based system, and that required us to have on-site presence, and we had to bring staff in no matter what the overriding government message was. We initiated a program of work to make our office accommodation COVID secure. So again, at this stage, the focus is still very much on the administration and getting staff in. But we recognised that it wasn't a sustainable position to continue to operate out of 4 court hubs. So we started a piece of work to try and make the court buildings COVID secure. That was things like making sure that we could achieve social distancing of 2 meters. It was things like making sure that we had the relevant PPE in place, whether that was hand sanitizers or masks, and that we had adequate supplies of those, which you will appreciate at a time was challenging. But this was all work that was focused on getting away from the 4 hubs and getting back to a more normal court estate. And we, a lot of that work came to fruition during August, and we saw that we were able to move. We opened another range of courthouses on the 10th of August, and then another tranche on the 24th of August. So we currently have 12 courthouses operational. During September, we hope to bring 3 more on stream. And that will mean that we effectively only have 3 court buildings that will remain closed for the time being. And they're 3 of our smaller hearing centres. It's not that they will stay closed, it's just that we haven't got around to doing the risk assessment of those and considering how they could be used. They are undoubtedly smaller. They will have more issues from a physical capacity point of view, but we will look to see whether we can bring them into service. I think whenever you talk about moving from 4 court venues to 12, that doesn't sound particularly impactful, but whenever you look at it at a courtroom level, it really is. I think we have gone from operating our business out of 4 courtrooms to the point where by the September, whenever we bring those other 3 courthouses online, we should have 45 operational courtrooms on any given day. We're also working to change the way in which business is done, and again, trying not to stray into Mr. Justice McAlinden's territory, but from my point of view, in terms of administration, we have been really increasing our capacity to deal with matters virtually. We have ruled out the use of a number of video conferencing solutions. So we have SiteLink, which is used in most of the criminal courts, and we have WebEx, which can then be used for tribunals, can be used for civil and family, and we also have WebEx, which is being used just for work being done in chambers, meetings, things like that. So we have been buying licenses for that so that we have greater capacity to work virtually. working virtually means different things. Working virtually can mean entirely virtually. So you could have somebody sitting, you could have a judge sitting on a laptop, and you could have everybody else sitting remotely working on laptops. And from an administration point of view, that's a nice, easy solution. But what's probably going to become more common is the hybrid style of hearing, where you have some people appearing virtually and some people attending physically at court. And from an administration point of view, that's a more challenging solution to put in place, because we need not just to have the ability to have WebEx or SiteLink, but we need to have the infrastructure within the courtrooms so that everybody can see everything that is going on. We have had an ambitious program of making more courtrooms dual purpose, so that they can do those hybrid hearings. And by the end of September, we would expect to have a substantial spread of those across the court estate, and we will continue to roll those out, because again, we think that's the way business will be done going forward. We know that
just in our best Northern Ireland tradition, can I give you a 1-minute warning?
You can, certainly. We know that working virtually will slow things down. I mean, a number of reports have said that working virtually can take 2 to 3 times the time to deal with a case that working physically would. We also know that some cases won't lend themselves to being dealt with virtually, either because of the complexity or because of the length of them. Virtual is, well, from my view, virtual is more suited to the short, sharp hearings, maybe not the very lengthy ones. So capacity is going to be an issue for us going forward. And we know that social distancing has radically reduced the capacity of our buildings. If I can just give one example, one of the biggest courtrooms in Laganside, which tends to be used for the big Crown Court jury trials, has a normal capacity of, I think, about 120, 125. And under the 2-meter social distancing, given all the fixed furniture, its capacity reduces to less than 30. So that's the kind of reduction that you're talking about. As a result of that, what we're also doing now is looking at external venues. We have engaged a strategic investment branch to look at what people are calling Nightingale courts. I'm not sure that term works well, but it's well understood. We actually had site visits yesterday looking at some venues which we would hope to bring on stream to give us more capacity, but also to allow us to deal with those more complex cases where the number of participants simply means that we wouldn't be able to accommodate them in the court estate. I can finish off with just one question, which I expect everybody will ask, so I'm going to ask it myself. How long will it take us to recover? And I'm asking that because I know the answer is I don't know. The Lord Chancellor, at quite an early stage, I think said to Parliament, or said in a media article, that he expected that it would take 3 years to recover from the impact of COVID. I'm not sure how that figure was calculated. I know that from our point of view, we don't yet have the data that would allow us to gauge how long recovery would take. We need to see how well these new ways of working work. We need to see how the throughput of business increases. Then I'll tell you how long it'll take to recover.
Thank you, Peter. So that's really helpful to get an insight into what the operational challenges are. Not just what you faced so far, but in fact in the recovery process. You've mentioned that your presentation would bleed into what Mr. Justice McAlinden is likely to say, so can I invite Mr. Justice McAlinden to speak also for 5 minutes, although it's going to be harder presumably to mute a judge, but I don't know, well, we can always try.
Everybody hear me?
Yeah.
I'm not sure if my video is working. I have a sign here saying that my camera isn't working, but I'm not sure how to fix that. So if you don't mind,
we have a lovely picture of you. We're all content with that.
Oh, that's brilliant. Excellent. Yeah. Excellent. It was taken some time ago, I'm sorry to say. Right, well, look, as with many other areas of life, this has been a very challenging time for the judiciary and the courts. The Lord Chief Justice and the judiciary have worked closely with the Northern Ireland Court Service throughout the pandemic on the recovery of the court estate. The focus remains on ensuring the safety of those working in and using courts and complying with public health guidance. We have engaged with the legal profession and others involved in the administration of justice with regular meetings at a judicial and official level. And the Office of the Lord Chief Justice has published guidance on the COVID-19 page of the Judiciary NI website throughout this period. The traditional model for the hearing of proceedings cannot be used under the current circumstances, and until social distancing measures are significantly relaxed. So hearings will continue, as Peter has said, to be a mixture of physical, that's people being present in the court, hybrid, which is some people in court and some people logging on by remote means, and exclusively remote hearings for some period in the future. So I would like to speak about the guidance which has been issued by the Office of the Lord Chief Justice during the course of the pandemic to date. The judiciary were quick to act in the middle of March when it became clear that the UK government was going to impose restrictions on non-essential contact and unnecessary travel. On the 14th of March, 2 days before the Prime Minister indicated that shielding and homeworking was imminent, the Lord Chief Justice alerted Crown Court judges to the potential disruption to jury trials. On the 16th of March, it became clear that this was inevitable, and it was announced that there would be no new jury trials until further notice. Now, on the 17th of March, the Office of the Lord Chief Justice published the first business continuity arrangements. Judges were directed that from the 18th of March, they should not require the attendance at court of persons who did not need to be there and who expressed individual concerns. The guidance stated that judges would continue to deal with priority proceedings, which typically involved issues of the immediate liberty of the subject, health, safety, and the well-being of individuals. Examples included first remands, bail applications, non-molestation orders, applications under the Children Northern Ireland Order, habeas corpus applications, and urgent injunctions and judicial reviews. The courts were still open to applications and all other matters, but these were to be made in writing, and a judge would then determine those that needed to proceed to a hearing. On the 20th of March, the Office of the Lord Chief Justice published generic guidance outlining the approach for all court tiers with the aim of developing consistent practice with judges managing cases as much as possible so that they would be in a state of readiness to be listed for hearing when court business returned to normal, or to deal with issues and cases as they arose. The general message was that courts would sit only to hear urgent matters or those where legal representatives or a party to the proceedings requested a hearing and the judge considered it appropriate. Cases would be dealt with remotely by way of sight link or other video technology unless the requirements of fairness, of justice required a court-based hearing and it was safe to conduct one. Legal representatives or parties were encouraged to complete forms drafted by the Office of the Lord Chief Justice should they consider the matter to be urgent. And I should say that the specific forms were tailored for use by personal litigants. Judges would then consider the information and determine if the case should be listed, and if so, what format the hearing would take. Court offices would inform unrepresented individuals if the case was being listed for hearing. On the 23rd of March, the Prime Minister announced a strict lockdown. So with effect from the 26th of March, all court business was consolidated into 5 venues or hubs: RCJ, Laganside, Lisburn, Dungannon and Londonderry. Members of the legal profession and the public were advised not to attend court if they were not pursuing a priority matter. Unless matters were flagged as urgent or necessary, a judge would adjourn them or could adjourn them without a hearing, and in most cases the adjournment period would be for a period of 8 weeks. Later that week, the Office of the Lord Chief Justice published guidance for the family courts, the Crown Courts, the county courts, magistrates and youth courts, and unrepresented parties litigants in person, which supplemented the generic guidance of the 24th of March. The family guidance set out the arrangements for interim care and supervision orders. It noted that the Trust's court's children's staff had been redeployed and all contact centres closed, and recommended that children continued to maintain their usual regime in compliance with the contact order unless it would put the child or others at risk. The guidance noted that temporary variations to contact orders without reference to the court could be made where the parents agreed or where one parent was sufficiently concerned that complying with the arrangements would be against public health guidance. The family court would later consider, when making further orders, whether each parent acted reasonably and sensibly in the circumstances. The unrepresented parties litigants in person guidance advised that if a litigant in person wanted any urgent matter to be adjudicated upon or wished to have an agreement between the parties approved, they should complete a form and lodge it with the court. The judge would then decide how to proceed, and the court office would advise what steps should be taken. The guidance continued to be developed throughout April, permitting the gradual and incremental increase in the amount of court business being processed. In April, the Court of Appeal and High Court started administrative reviews of cases with legal representatives being asked to collaboratively complete forms designed by the Office of the Lord Chief Justice, setting out the current position of the case. Judges would then consider the information provided and included in the case files and determine a way forward, which may be to issue directions, request further information, list the case for review on an allocated review court date, adjourn, or list for a priority hearing. Where a review hearing was required, it would be undertaken remotely. On the 12th of May, further guidance for the various court tiers was published. Unrepresented parties litigants in person were reminded that they may enter a plea of guilty by post to certain offences. In family proceedings, the guidance announced that reviews of outstanding family care centre business would be undertaken, and parties were encouraged to lodge forms to request a hearing or administrative determination where they felt a matter of contact was urgent or matters had been agreed. The guidance also announced a pilot review of non-urgent FPC cases starting in Ards and Lisburn on the 8th of June. By the first of
Jerry, sorry to interrupt. Can I give you a minute just to?
Yep.
Yeah.
By the 1st of June, the Court of Appeal held its first contested case since lockdown. As Peter has mentioned, this was made possible by Northern Ireland Court Service risk assessments and the implementation of social distancing and hygiene arrangements. These reduced the capacity of the Nice Price Court by 3/4. The Public Health Agency approved the arrangements, which continued to be followed for physical hearings. Where the numbers involved in the proceedings exceed the capacity of the court, a hybrid hearing may be facilitated with some parties physically present in court and others participating by sight link. So then the 5th of June, the LCJ initiated a programme of work to proactively recover court business. The first phase primarily involved administrative reviews of cases across most tiers, with the aim of gradually increasing the disposal of business whilst adhering to public health guidance. In this period, cases would proceed, but at a slower time. The reviews permitted an increase in the number of arraignments, pleas and sentencing in the Crown Court being dealt with, along with pleas and sentencing in the Magistrates and Youth Court. Phase 2 would see the commencement of jury trials in more complex contested cases. On the 16th of June, the LCJ advised the profession that he would make judges available to review and hear Queen's Bench actions over the summer recess. Representatives were asked to collaboratively complete and lodge forms for cases listed for hearing and review. The court would be available to sit every Monday and Tuesday during the period 20th of July to the 1st of September to deal with up to 6 actions per day. And then on the 8th of July, the presiding district judge agreed with the legal profession to pilot contingency procedures for a daily sentencing court in Lagenside commencing on the 22nd of July. This would start with the listing of Court 9 summons matters for pleas and sentences where the defendant did not need to be present or require a PSR. This court was to operate remotely, but a physical hearing could be accommodated should a legal representative need to appear in person.
Jerry,
Yep.
I might I might do the unthinkable and have to cut you off.
That's fine. I'll just
of 3 other speakers.
Yep.
Is there a kind of forward-looking piece that you wanted to finish on?
Well, basically, we are trying our best to get everything up and running to as normal a standard as possible. There have been obviously a number of high-profile cases dealt with during the first jury trial has been completed, and it's hoped that in the term coming up there will be a number of significant cases dealt with, both by way of remote hearing, by way of hybrid hearing, and by way of full attendance in court. Every effort is being made to try and ensure that the administration of justice in this jurisdiction is as normal as possible, given the exceptional circumstances that we now have to operate under.
Okay.
So, okay, thank you.
Thank you for that. Appreciate the detail of what's been set out, and shows that the necessary level of planning that had to be done that was responsive to the circumstances thrown up by the pandemic. So that was the one of the views from the bench. What we'd like to do now is to hear the view from the other side, from the personal litigant's perspective. So if I could ask Jerry McKerney to come in, and we'll mute everybody else. And Jerry, if you're there.
Apologies, Ramsey. Can you hear me now? Yeah?
Yes, that's great. Thank you very much.
Your technical difficulties here, so apologies to all involved. I would just sort of like to answer, or really even discuss, I think a 3-strand approach. I know it's 5 minutes. I'm going to give you a brief synopsis of the difficulties that COVID has had for myself as a personal litigant. I would like to discuss how it has affected me personally with my case. I'm also a social work practitioner. I would do sight-link in the court process almost every day. And I'm also a volunteer with different parental organisations and how it's affected them. So first of all, my own case has been quite sadly intractable for the past 8 years. I've been involved in a family process for a period of 8 years, so it's incredibly complex. And in December last year, unfortunately and quite sadly, the children's mother had passed away. So the grandmother had applied for an interim order and was granted. And there would be a formality hearing in January of this year. In January this year, the grandmother applied for a full care order. So the judge had to put it off to a full hearing, which was in March. Now, on March, as we all well know, COVID had then kicked in. So for a temporary interim hearing, we're now 9 months into the possibility this interim order has now become the norm. And it's been quite difficult and quite complex as well. So within that process itself, although our family care system was never perfect by any stretch of the imagination, it's all that we had, and we worked along with what we had. However, the COVID situation itself has obviously created further hurdles and made things quite difficult. On a personal level, I feel the case has been maybe abused by the other side, and to the systematic approach of the further the case is going to drag on, the more detrimental it will be from my viewpoint. So the case has been allowed to be cut into drift. As a social work practitioner as well, I would do sight-link almost every day with young people in my workplace. And, with the confidentiality aspect of it as well, we're on sight-link. The case is supposed to be quite personal and quite private. However, if you hold on to the sight-link process itself, after the court process, you can hang on and hear other people's cases, which is quite sad. As a volunteer in different parental organisations, regarding even when Justice McLinden said there was a process for documents and whatever it may be, they were quite confusing at first. So to try to access those documents and to make sense of those documents, but it was always quite hard and quite difficult to process. So even if small things such as even personal litigants would have the support mechanisms of a Mackenzie friend, and trying to introduce a Mackenzie friend into the process of the sight-link process was quite difficult. You still hear me okay, yeah?
Yes, great. Yes.
All right, we're breaking up there. So just generally overall, it's been quite a it's been quite confusing. It's been quite unambiguous as well. There's even different judges in different courts. There'll be, even with the parental organisations that I'm involved in, you know, different courts would have different viewpoints of what the severity of a case would be. Different judges would also have the different viewpoints of how severe a case would be to come into hearing. And even, you know, the family matters are actually quite intimate and quite difficult to put across. Even when you're on a one-to-one basis sitting in a courtroom discussing with a judge, it's even more difficult when you're on a computer screen, trying to put your process and your emotions and your determinations. And judges, and I have a lot of sympathy for the judges as well. They have to make those determinations on what's in front of them. So it's very much like an administrative process. You know, administratively, you're trying to cram everything into a court report or a legal document, and you're hoping that the judge is going to pick up on how those cues are. So that's pretty much it, Brenda. Sorry.
Sorry, Jerry, that's great. Thank you so much. It's a really valuable perspective, and I think it's probably echoed. We're starting to see some questions in the chat, the issue of delay and the impact of not having firm contact arrangements in place for families. So really appreciate the insight that you've given us. It's invaluable. Thank you. If I could move now to Suzanne Rice from the Law Society and hear that perspective, that'd be great.
Everybody, I hope you can all hear me. I'm trying to talk up a little bit louder than I normally would. My sound is a little bit faint, I believe. I'm approaching this commentary on behalf of really a dual process, which is on behalf of the Law Society, where I'm Senior Vice President, but also from the family solicitor's perspective as well, and that's because that's my area of specialisation. I suppose at the outset, what I would want to focus on is where we have gone through and what we've gone through in the last 6 months, give or take. We did notice as solicitors fairly early on the move that there would be needed to ensure that our businesses stayed open. And we wanted to make sure that regardless of lockdown, clients had access to solicitors and legal advice. And my colleagues and I were very good at moving our businesses essentially to the virtual sphere very quickly. As a family practitioner, working on the likes of WhatsApp and social media platforms and virtual platforms is fairly familiar for me because I would have a number of clients that would live outside the jurisdiction. So really what I noticed on the ground was more ramping up of that style of process. But what we did recognise within the Law Society very early on is that there was a lot of information starting to flow from different stakeholders, as we call them, within the justice system, such as the judiciary and the court service, and wider afield with, for example, the support services through social services. And whilst everyone, I can say, was approaching the process with the aim of trying to keep things on track as much as possible, the message universally was becoming quite disjointed. And it was very important then on behalf of the Law Society that we took steps to bring everybody collectively together. And what I did notice moving forward, which I hope is something that we can continue to build on, is the very successful collaboration that has been occurring over the last 6 months. One practical example I can give of that is in the area of domestic violence legislation, where early on we recognised that those applications would still need to come into the court building, even if the court building wasn't physically open for clients. And so through communication and dialogue, we were able to have flexibility around procedural rules, relaxation to allow statements to be put into court by way of email without a client physically having to sign the statement. And that has allowed, as Justice McAlinden referred to, the emergency applications continuing. That said, I fully recognise that over the last 6 months, there has been a significant reduction in the amount of work that can be and has been processed. And one of the major impacts that I've seen as a practitioner has been in the area of contact, in other words, access between a parent and a child. And Jerry has already touched on how he has been involved in that on a personal level. Sadly, contact was not defined under the Office of the Lord Chief Justice as an urgent issue, and therefore any issues sparking between parents, even if it was in relation to existing court orders, fell into the non-urgent business category, which meant that only now, moving forward, are we starting to see those cases coming back into the court system. For the life of a child, any delay is inexcusable and unjustifiable, and we have to take recognition that for 6 months in some families, there has been such a significant deterioration in contact that what was once face-to-face contact has eroded away, perhaps even to no contact whatsoever. And with the best will in the world and setting those cases back on the court track, so to speak, we have to be mindful that there will be an impact with those families. And it's not simply a case of picking up where we left off. So whilst I was extremely encouraged to hear feedback from the judges that if parents have maliciously used COVID-19 for their own personal benefit to deny contact, that there would be obviously an investigation into that in due course. We have to be mindful though that in the life of a child, 6 months has now gone past, and how do we build and make up that time that has been lost? So that is going to be a challenge moving forward without a shadow of a doubt. Within the business structure of solicitor firms, we've obviously renovated premises to make sure that they are COVID-19 secure. And we are getting used to the hybrid way of life, which is where a majority of us are still working remotely from home and coming into the office as and when required. There are positives, I have to say, to the new working environment. I've noticed personally that the time that I spent outside a courtroom has been reduced significantly through cycling. And I'm finding that on that basis, my time management is much more efficient, and I'm able to process a lot more cases in one day than I would normally. That said, I do recognise that not all cases are suitable for cycling, and that it is a case of making sure that we have access to justice, but it's done in a way that makes sure that at the end of the day, justice is seen to be done. And there are cases perhaps which there does need to be not only a hybrid model operating, which is where some parties are physically in court, but there are cases which are only going to be able to proceed by in-person hearing. It is quite clear that we are still transitioning through this situation, and COVID-19 will continue to challenge us. And we will have to keep thinking how the courts can continue to operate without compromising the justice system or the health of practitioners. And each week does bring its new challenges. I'm very keen that this is very much a starting point in terms of my commentary, and that we can move forward to look at more bespoke issues as and when they arise. But certainly the fast tracking of digitalisation, which COVID-19 has produced across everyone involved in the justice system, I hope is the start of things to come, and that we do look at some of the positives and retain them as we move forward. Unfortunately, I am under a time restriction in this commentary, so I can't really get into much more information, but I would like to just flag up that obviously the court experience is about socialising with your colleagues, learning from their experiences as much as your own. And we do have to recognise that cycling, for example, is not going to give us that valuable learning environment, and that is going to be an impact for our younger generation of solicitors as to how we equip them with courtroom skills when those courtroom skills have changed dramatically overnight. So I hope I've given you enough food for thought in terms of some of the issues as I see it. And as I said, I hope that this provokes more commentary as we move forward. Thank you.
Thank you so much, Suzanne. Really good to see the commonality coming through in these issues, particularly around family contact issues, and the taking the positives from the pandemic as well as meeting the challenges that are there. So thank you very much for that. Really appreciate that. And finally, our final speaker is Sarah Ramsey. So Sarah, whenever you're ready.
Thank you, Grania, and can I just thank the other speakers who've really set out the stall in relation to what has been happening as a result of the COVID crisis. So COVID-19 has presented significant challenges to the justice system in Northern Ireland and beyond. The stay-at-home determination resulted in a significant reduction in court business. In April, we surveyed our barristers, and 91% of them said that they were doing less than 10% of the work that they had been doing previously. Now, anecdotally, I can say that that has not increased significantly since that date. In July, it was reported that in the local media that around 4,000 new criminal cases needed to be issued by the Public Prosecution Service to defendants across Northern Ireland. While there has been a gradual and incremental recovery of court business, the most recent guidance issued by the Office of the Lord Chief Justice has a focus on as much business as possible being dealt with remotely. Excuse me. In tandem with that, jury trials have recently resumed in Belfast, with further venues for Crown cases likely to become operational by mid-September, and that is to be welcomed. The Bar has continually worked with colleagues in the Law Society, Northern Ireland Court Service and the Office of the Lord Chief Justice to enable a full resumption of business as soon as possible. And I think Peter had set out that since March we have been having regular multidisciplinary meetings to try and ensure that we can get as much up and running as possible. Indeed, in July, the Criminal Bar Association, in conjunction with the Law Society, developed a proposal roadmap for the opening of criminal courts with innovative recommendations aimed at getting business resumed as quickly and as safely as possible. And these included increasing court capacity by exploring utilisation of leisure centres, theatres and conference venues. And can I say at this stage that it would be a misnomer, and I hope that the public do not think that the main issue in relation to obtaining courts pertains only to jury trials. I see that one of our QCs, Adele O'Grady, has raised an issue in the comments. There are numerous family cases which have a number of multiple parties, which means that there are significant numbers of people in courts. Now, what that means is with social distancing, we have a very limited number of courts that have the capacity to take on these cases. And since March, the Bar has been asking all the stakeholders to look at the potential of what we call Nightingale courts or Blackstone courts, which is really finding alternative larger venues which will ensure that we can find court time for all these cases, because we do feel that it is an access to justice issue. If people don't have the ability to get their cases on and cases heard, and I think Mr. McCartney had raised something like that, that can have significant implications for families, for victims, and for defendants going forward. So the pandemic, alongside the introduction of social distancing measures, has seen the courts in Northern Ireland rapidly adapt to the use of remote telephones and video hearings, these site-link hearings, for a range of proceedings. And the Bar undertook a survey of members on the operation of remote hearings in June. While the majority of the respondents felt that the remote hearings were a necessary short-term measure, they indicated the system is not ideal and presents a number of challenges. Firstly, technology breaking down, clients being unable to use the technology, difficulties in relation to delay, difficulties in relation to obtaining a number of site-link courts, although Peter has set out that there are more licenses purchased. Childcare issues. A number of our members have families, children were at home. It was increasingly difficult to try and conduct hearings whenever they were looking after children at the same time. Now, hopefully with the opening of the schools and the children going back, that's going to resolve that issue to some extent. Taking instructions, that's a very important part of the barrister's role. They need to take instructions from their solicitor and they need to take instructions from their client. So what we found was that during consultations, clients were finding it very difficult to use the technology. We do regularly use Zoom consultations, but sometimes that was difficult. Again, we perhaps had clients who had children who were the subject of the proceedings, and it wasn't suitable for them to have children listening in to legal consultations. And also, very importantly, there's a significant limitation in relation to site-link hearings in that you cannot take instructions whilst the hearing is proceeding. And that's something that can happen when you have an in-person hearing. Invariably issues arise, instructions need to be taken, and we feel that clients are being disadvantaged significantly by not having the opportunity to have legal advices or have instructions taken whilst remote hearings are ongoing. We feel it's an access to justice issue. So I suppose in summary, the sentiment was echoed by a number of times in our survey was that remote hearings are no substitute for presenting oral argument in court. And one member said, I cannot presently envisage how evidence could be successfully handled with live instructions being taken on issues that may arise, and they don't feel inclusive for the clients affected. So what has the experience been in other jurisdictions? Well, if we look at Scotland, there are 750 outstanding High Court and Sheriff Court cases as a result of the courts being closed by the pandemic earlier this year. Jury trials recommenced in Scotland in July, and judges will hear trials remotely from cinemas to stem the growing backlog of criminal cases. But the recent Faculty of Advocates member survey said that the substantial majority felt that remote hearings should not, post-COVID, be the default. In England and Wales, again, there's been a substantial backlog, more than 500,000 cases in England and Wales. Jury trials began in June, and 54% of the 341 Crown Magistrates, County and Family Courts and Tribunals across Wales and England are now open for essential face-to-face hearings. And again, in England and Wales, the court service there is using additional venues to provide increased estates capacity in response to the coronavirus outbreak. And again, we're referring to the Nightingale or Blackstone courts. It's envisaged that these courts will be used on a temporary basis to ensure as many hearings as possible can continue to take place during the coronavirus outbreak. Fair Trials, the global criminal justice watchdog, carried out a survey of the criminal justice system in England and Wales between March and May 2020. In relation to remote hearings, the results of the survey largely supported findings of existing research on the challenges regarding the use of video link in criminal court hearings. In particular, defendants' rights are being undermined on account of the difficulties in communicating with their lawyers in the court and in reviewing and challenging information relevant to the proceedings. The survey found that 44% of respondents believe that remote hearings make it significantly more difficult for defendants to participate in the proceedings. 67% of respondents thought that the remote hearings had a significant negative impact on the ability of defendants and their lawyers to communicate before and during hearings. And 75% of respondents believed that remote hearings had made it harder for defendants and their lawyers to obtain, present, and challenge evidence. So I suppose, in summary, if we look at what has been happening, the bar has responded immediately and in whatever way it can to the pandemic, engaging with the remote system, and we will continue to do that. But it does have significant limitations, and it would be wrong for anyone to think that we can continue to have as robust a court system as we had previously without in-person hearings. It is clear to the bar that the current court estate cannot sustain the number of in-person hearings that are required. And I heard Mr. McKerney speaking about his concerns in relation to delay. Again, anecdotally, I have family cases that are ready to be heard today, where we're being given dates of March for hearing, and that cannot be access to justice for clients.
Thank you, Sarah. That's thank you to all of our speakers for giving us a comprehensive run through. Not quite sure we hit the 5 minutes on everybody's, but definitely worth listening to hear what was being said. And again, the kind of common issues that are coming up. We have some time left, not a huge amount, but if we wanted to look at some of the questions that are coming up, the ideas around what we can take from this pandemic experience around contact issues for families in particular, the impact that that's having on how the professions are able to engage with clients, how litigants are experiencing the system, how judges are struggling. We're hearing lots of anecdotal evidence. So I guess one of the questions is that, I mean, so a lot of the things that we're hearing are quite common in the findings from the Civil Justice Review and the Family Justice reviews that were done, the rapid reviews in England and Wales. So there's an instance in this seminar where we're hearing anecdotally, effectively, from everybody on the experiences. So what evidence do you think we need to inform more strategically the recovery that would allow us to address those access to justice issues? I think that's kind of one of the questions that comes out of today. We have issues around how SiteLink and remote justice have been working and the limitations on that. So I guess trying to take some of the questions in the chat box. People have been very reserved, so presumably they're still listening, but they haven't put too many questions there. Eamon McNally's perspective coming from the Children's Law Centre, which is a perspective, of course, that we haven't considered. So it's not just the impact on litigants, but it's the impact on families we've mentioned as well. What is in family courts, what do our speakers think should be the priority, given that contact cases were not deemed to be urgent? Is it the best of the worst of the best that we can do to have SiteLink hearings, even though they will be difficult in contested spaces? Is it the need to expand the family justice estate? Is there mediation that should be looked at, or what do our speakers think would be the kind of most useful way to progress those cases, particularly given, as Suzanne has said, 6 months have already passed, and 6 months in the life of a child is a substantial period of time. Could I perhaps address that to Jerry McAlinden first, and then I'll come to our other speakers?
Well, in terms of the High Court tier, and I know from being in here all summer that Mrs. Justice Keegan, once she was made aware of issues concerning contact, did list a large number of cases and has continued to list a large number of cases where contact has broken down, where there are problems with contact, and she is aggressively and proactively dealing with those cases to ensure that those contact issues are addressed. So I can say at the High Court tier, where the complex cases are involving contact issues, she's on top of that, and she is assiduously following up at this particular tier all contact issues that are being raised with her. Okay. So it's not that that issue has been missed. It's certainly, it may not have been regarded as an issue that was initially urgent, but where issues are brought to the attention of the court, action has been taken to deal with those issues as quickly as possible. Okay, and Jerry McKerney, just to kind of bring your perspective in on this, so you had mentioned that there was guidance available for those who didn't have representation, who could make a request for an urgent hearing in the courts. Did that seem to you as something that you could rely on to bring that contact dispute that you've outlined in your case, to bring that to the court sooner?
I don't wish to minimise the impact of the documents that were presented, but they seem to be like a token gesture. There was no real clarity to it, and even in the contact cases, there's different levels of severity to contact. And I can only speak on my own behalf, obviously, for confidentiality of others that I've worked with. But with my case, my children, it's been 9 months. So 9 months, my children are teenagers. So for 9 months in a teenager's life is absolutely massive. It's huge, developmental changes and whatever it may be. But the court documents themselves, there was no real giving clarity to it. And even the support mechanisms with the court, the old-fashioned way of actually picking up the phone and speaking to a court clerk and asking for advice and direction and so on, that was quite frustrating. That wasn't happening. So you really had to decipher through these documents. I'm by no stretch of the imagination a lawyer or a solicitor or a barrister. So the support groups that we were involved in, we had to sort of sit down with ourselves and go through these documents bit by bit. So I'm grateful and I'm thankful that there was a mechanism put in place. However, it wasn't maximised, and it should have been more efficient than it actually was.
Okay, thank you. Sarah and Suzanne, you've both mentioned, I mean, the survey that was done by the Bar Council sounds like a really kind of useful piece of evidence. I'm not sure if the Law Society has done similar, but bringing those perspectives together, would that be a useful way to ensure that there is an evidence base to look at what the strategic priorities in family cases should be, and how would you want that to be approached?
Well, yeah, we have in the Law Society carried out a survey, but it was more to do with the impact on businesses as opposed to individual areas of work. If I could respond briefly, just to say that I think it's important we all remember that in children's cases, it's an inquisitorial approach we take as opposed to adversarial. And certainly in a case that I'm involved in at the minute, it can proceed by way of side-link, by way of detailed statements being filed. However, I recognise that not all cases are necessarily suitable. But where the problem has appeared, and how I think we need to now focus on moving forward with these issues, is that very often in family cases, what is required is a judicial input, some sort of reasoning to be given to the parents to allow then perhaps what was the sticking point of the obstacle to be reconsidered and overcome. And what we really missed during the lockdown period in particular was that review court, that opportunity to, at a very basic level, put your client's case to the judge to get some sort of interim provision or interim way forward. And that is not a full hearing, but it would have allowed at the very least the impasse on the ground maybe to have improved. And that was really where we felt not being able to bring our clients' cases to court under the heading of contact disputes really did significantly then impact. And that is now where we are at, which is where the cases are now being reviewed on either an administrative front or by way of cycling to see if cases can be moved forward to the next step. So I think that's important to make that distinction when we're having a conversation around the difficulties with contact cases.
Okay, Sarah?
Yeah, Grania, if I could just pick up, there are some situations where remote or site-link hearings are just not suitable. And the types of cases are, first of all, where it's important for the judge to determine the veracity of the evidence that's being given. It's just impossible to try and determine that over a video link. The second type of situation would be where there are a large number of documents. Again, it's just not practical for everybody to have a bundle with them and to work to that. And another type of situation that I have found is where you have interpreters or people with limited learning or understanding. It's just not possible. And another situation that I have had my experience is where there's a very serious outcome to the case. If we have a situation where a mother is going to lose her children for the foreseeable future or forever, that's not a suitable case to run that by video link hearing. So when we have those types of situations, what we've got to remember is we are competing with all the other court hearings. We're competing with criminal hearings, we're competing with child abduction hearings, we are competing with all those different types of circumstances. And I think Mr. Justice McAlinden had set it out very well. It's not the contact disputes have been forgotten about, but at the moment we are still in a situation where we are triaging cases, and public law cases where children are at risk of physical harm, and I'm by no way trying to minimize the emotional effect of not having contact, but when we're in a triage situation, that's invariably going to cause limitations to the access to justice that can be provided to clients.
Okay, Peter, is there anything that you'd like to add on that?
No, I think all the commentators have been spot on with it. I mean, it is the case that we need to make sure that we increase the capacity, and we have increased the capacity. Whenever you were trying to have all the business being done by 4 judges sitting around Northern Ireland, they just didn't have the ability to focus in on the caseloads that they had. Anecdotally, I understand that now that lists are going back to local judges and they're managing their own business, a number of solicitors have said you can see a real change. You can see a real focus on the part of the judges to get cases progressed and dealt with, and we need to make sure that continues. I agree entirely with Sarah. I mean, the use of technology needs to be appropriate, and it isn't going to be appropriate for all types of cases. I'm not sure that I would be quite as not sure if negative is the word. I think we have used technology to allow people to give evidence for years in vulnerable witness cases and in crime, and I think it is possible to assess evidence given by live link, but I do think that family cases raise a particular dynamic which I think needs to be very carefully managed, and that's why we are looking at external venues, because Sarah has said to me repeatedly that the high-end cases, the more complex family cases, because of the number of participants, we won't be able to accommodate those, so we need to work out how we do that by going to external venues, and that's they will be prioritised under the Nightingale project.
Okay. I'm conscious of the time. We didn't quite stick to the 1 hour slot, but we did begin a little later than 10, so perhaps we're closer than we thought. I mean, what I'm hearing from this is that there are still huge issues, understandably. There are issues that are coming out that are common to those that have been found in the civil and family justice rapid reviews, but there are other points that I think that are particular to Northern Ireland that we need to kind of understand and to investigate further. I'm really hoping that this is the start of the conversation that will continue in whatever venue and across all of the jurisdictions that we have today, from litigants through to professional, the professions working in the court service, all of the practitioners connected to that. And to try and pick up some of that stuff, we might look and see what future steps that we could take to convene some work and some research on how we could realistically bring together all of those views in an impactful way to understand the priorities that need to be addressed and how best to address them to meet the concerns that have been raised about the digital technology, the digital poverty, as Eamon McNally has pointed out, the technology issues, the fact-finding, all of those things that are common across the UK but have a particular bearing on cases now in Northern Ireland. So just remains for me to say thank you very much. I wish we had more time, but everybody has got stuff to do. I'm really, really grateful to our speakers taking time at the start of the judicial term, and particularly when you're exceptionally busy. Really grateful to Jerry McKerney for speaking about his own personal experience. That can't be easy, and it's such a valuable insight. We will save the chat and keep the questions and try to see what best way we can follow up from that. But in the meantime, thank you all very much. Really appreciate your participation today. Thank you.